Well, as you said, it is now official. The no decision by the U.S. Supreme Court on Idaho's abortion ban with regard to federally mandated emergency care, well, that was issued today. For reals this time. It's exactly as we described it yesterday, by the way, after it was inadvertently posted prematurely on the SCOTUS website. In a 6-3 opinion, the court dismissed the case, saying they shouldn't have agreed to hear it so quickly. They punted, basically, kicking the can down the road without taking a stance on it. What this does is send it back to the Ninth Circuit Court of Appeals. The lawsuit's last stop after the Department of Justice filed that lawsuit against Idaho in August of 2022, just before Idaho's near-total abortion ban was triggered. So what this means is the injunction preventing the law from being enforced is now reinstated. That's the last order that was issued by the Ninth Circuit, and while they decide what to do with it from here on out. This does not mean Idaho's abortion law is not enforceable, but only how it relates to EMTALA, the federal law guaranteeing anyone gets stabilizing emergency care. However, it is narrowed, though, since the government made concessions saying their interpretation of EMTALA was too broad at the beginning. As Justice Elena Kagan wrote in the opinion issued today, it will prevent Idaho from enforcing its abortion ban when the termination of a pregnancy is needed to prevent serious harms to a woman's health. But as Justice Amy Coney Barrett pointed out in her take, even with the injunction in place, Idaho's ability to enforce its law remains almost entirely intact. Of course, both sides are claiming a win in this. The injunction protects women, pregnant women, from having to go out of state to get the care they need when it comes to emergency complications. But the law remains in place, which is just how Idaho's Attorney General believes it should be. Exactly how it was written, to protect the life of the mother. As for her health,
But what I want people to understand, I want doctors and the public to understand, is that even our law, without this Supreme Court decision, our law says that if a woman's life is in jeopardy, that the state of Idaho allows abortions to be performed. There's no immediacy requirement that a woman's life is in jeopardy at that moment. It's if a doctor in good faith has a good faith belief that a woman could potentially die because of the situation that she's in, that our law already allows for an abortion for a pregnancy to be terminated.
But you understand that doctors are telling us that they don't believe that.
They don't believe that because they're being misled. Number one, they're getting confused by what some of the pro-abortion lawyers are saying out there about what our law says, that our law is unclear, and our law is not unclear, our law is really clear. But I also think that they have a concern because they're misunderstanding. They think that this is very similar to medical malpractice. So they're afraid that every doctor in Idaho is going to be prosecuted if they find themselves in one of these difficult decisions that they have to make. But the standards for medical malpractice and for prosecutions are so vastly different. If the doctor in good faith has a subjective belief that the abortion is necessary, there's no way that a prosecutor in Idaho is going to prosecute that doctor.
Okay, that was my next question. So if the doctors don't feel like they're covered, how do you make them feel like they're covered?
I'm having communications and conversations with doctors, with executives, with hospital administrators, and anyone, and I've invited anyone who wants to come to my office, or I will go to them, actually. I will go to their hospitals and talk to them about these issues. The law is actually not as confusing as some people are making it to be. I understand why some doctors are concerned because it is a change in the law, but these are decisions that doctors make every single day. These life and death decisions they make every single day.
Lastly, and I have to ask you about this because you said this on the steps of the Supreme Court that you'd spoken to several doctors.
And it's really hard for me to conceive of a single instance where a woman has to be airlifted out of Idaho to perform an abortion. In fact, I have talked to doctors in the ER, the same ER rooms that they're talking about, and they are telling me that they have no idea what this administrator is talking about.
I said two things. I said that I had no idea of anybody being sent, that the people that I had talked to had no idea of that happening. But second, which is important, I said, and